I can only say that the themes that we are dealing with here, they're fairly familiar. We deal with the questions also in Danish law about the relationship between Parliament and the judiciary, and also the question, can you criticize a judgment from the Supreme Court? Is it something that will contribute to legal uncertainty or perhaps interference from the Parliament, which is damaging to the state of law and order? I come from Denmark, which is a country that belongs to the civil law tradition. And now I've learned while being here in Pakistan that the Pakistan legal system is sort of a mixture between common law and civil law, different legal traditions. From a civil law standpoint, I would say that we have courts which are not very active courts. Our judges are not democratically elected and are even not politically appointed directly, as we see it in, for instance, the United States. Our judges are merely technocrats, which are meant to be, as Montesquieu said, the mouth of the act. And what their job is basically to focus exclusively on how to interpret the act as it was meant by the legislator. So all our focus as lawyers is on what Parliament meant when they adopted the Act. And we look very much into the history of the Act, of the travaux préparatoires, of the preparatory work, when we try to interpret the Act. Denmark is also a part of the European Union and the Council of Europe. And in the European Union, we have a European Court of Justice in Luxembourg. They are more sort of a mixture between civil law courts and a common law court. And what we can see there is that we have some partly politically appointed judges, but they are to be totally independent. They sit there for many years, and they are in the sphere of independence because they represent the European Union and not the individual member states which they come from. And if we look at the way activism is performed by the European Court of Justice in Luxembourg, the European Union Court, then I must say that it is a more activistic court than we find in most of the civil law countries. They take their liberties to sometimes come up with some very free elements of interpretation. And that is a part of the tradition, and it can work and also work very well in democratic legal order, but it is something that has developed over time. So the fact that the European Court of Justice in Luxembourg are now allowed to be rather free in their interpretation, you can say activistic, is partly due to the fact that we have a long history of development of European Union law. In the very beginning, the European Union was basically a union which dealt with coal and steel and stuff like that, something that was not close to people's lives. But over the years, the European Union has developed, and now European law is very much interfering in the life of all Europeans, all the Europeans from the member states of the European Union. It took merely 60 years to get there, and that means that the first judgments which came, they dealt with coal and steel, they dealt with business law, they did not directly interfere in people's lives. And over many years, the European Court of Justice got recognized for making these judgments. And to the degree that the European Union did not agree upon this, then the European institutions, including the European Parliament, the European Commission, they could alter the European law in criticism of the court. So there's been an interplay there. So just to say that, in my understanding, at least from this question about judicial activism, it's very important to have these independent institutions which are respected. And that respect is something you earn over time when it comes to law, or at least you have to be totally sure that these institutions have their freedom. If I finally may address the cooperation between the courts and the parliament, I think it's, at least from a Danish civil law point of view, considered a part of the balance of power, very necessary to be aware of where you take the political decisions and you take the political decisions in the parliament, and where you make legal decisions. And while the Danish Supreme Court has sometimes been, in a very limited way, activistic, it's not their job to be politicians. But that is because they are not democratically elected in Denmark. It's not even that they are appointed by the president. We don't have a president, or by the ministers. So the job of the Supreme Court is not to be activistic. That's the difference to, for instance, the United States. And just to name one example, Denmark passed an act in November 2023 about the banning on the burning of holy books. This was a parliamentary decision. It was a political decision to do so. And in my opinion, and I believe in most lawyers' opinion, this was a decision that should be made by the parliament. This was not a decision that should be made by the Supreme Court, because they don't have the mandate, in fact, to make political decisions. So out of a democratic process, the majority of Parliament, they adopted this act. In a civil law society, it would be very difficult to make controversial political decisions, as we see it in the United States, for instance, in the abortion issues, with their acts dealing and giving up old practices regarding that issue. It's just not the main understanding we have in civil law. But to sum up, to be able to be activistic courts and to be able to be respected, in my opinion, it's something you need to earn over a period of time, where you gradually ensures people that you have the respect, you have the independence to perform that task. Thank you very much.